The recording has started.
Okay, thanks. It is 1 o'clock on October 9th, 2025. This is a meeting of the Land Use Review Board. I am Janet Hurley, the chair. I will ask board members to introduce themselves as I see them on screen. Kirsten,
Kirsten Sultan, board member present.
Alex,
Alex Weinhagen, board member.
and Brooke. Everybody moved around on me all of a sudden. Sorry, Brooke Dingeldine. Okay, and Sarah Had is present, is not present at present. So first on the agenda is any changes to the agenda. Brooke, you have one?
Yes, please. I want to move to amend the agenda for item F, small a. We had planned to do an appeals draft report review. We will not be going over a draft report. There may be a short update, but I wanted to be sure that anyone listening was not going to wait for a more robust conversation than will ensue.
Okay, thank you. I'm good with that. Do we have a second?
Second.
Oh, wait, thanks. Rachel, do you have a question about that?
I don't have a question about that, but another amendment. So.
Oh, okay. So we have a motion to amend the agenda so that we are having an update on the appeals work, but not a review of a draft. Any further discussion? All those in favor, please say aye. Aye.
Aye.
Aye.
And Sarah Had has joined us, and she also voted on that motion. Sarah, you want to introduce yourself?
Sarah Had, board member.
Thank you. The next item is opportunity for public comments on non-agenda items, and I see we have Thomas here. Thomas, do you have any comments on non-agenda items?
And Janet, I think that Rachel had another.
I forgot. I'm sorry. Rachel. Sorry, Thomas. Hold on. Rachel.
Hoping that a board member may move under agenda item D sub A. It references the FY27 budget, but I would also appreciate talking about the FY26 budget adjustment today in addition to that.
Yes, absolutely. Thank you.
So moved.
Okay.
So
and
seconded.
Kirsten seconded it. Okay. Any discussion? All those in favor, please say aye. Aye.
Aye.
Aye.
Okay. And Thomas, do you have any comments?
I do have comments. Thank you. This is Thomas Weiss, resident of Montpelier. And I would like to comment on an item that came up at your meeting on Monday. I would like to comment on Tier 3 and logging and forestry and agriculture. Act 250 has established by tradition, I suppose it's by tradition, that there are various uses: residential, commercial, industrial, agricultural, and forestry, among others. The definition of development limits jurisdiction in Tier 3 to the construction of improvements for commercial, industrial, or residential purposes in the Tier 3 areas as determined by rules adopted by the board. Thus, I don't think there is any need, and I think it is counterproductive, to provide exclusions in the rule for agriculture or forestry or logging. I say counterproductive because introducing unnecessary exclusions of things that are not included casts doubt on other parts of the definition of development. And I can see the reasoning going, well, if the board thought it necessary to exclude logging and agriculture from Tier 3, when they apparently were never in Tier 3, Well, maybe that means that somehow they really were under jurisdiction in Tier 3, and that raises similar questions in all the other parts of the definition of development. I realize that's a little far-fetched, but my experience in construction contracting and in contracts for design and planning is that you try not to introduce those kinds of potential conflicts that can lead to problems later if things go bad on the project. And just because members of the working group suggest items that conflict with statute, and I believe trying to include exclusions of forestry and logging do conflict with statute, doesn't necessarily mean they should be brought to the board. I would think if it's in the draft, it should be accompanied by a written statement that indicates it was mentioned in the working group, and hopefully the lead board member is actually recommending it not be included in the rule. I'm particularly concerned about statements from ANR because of the governor's consistent opposition to the expansion of Act 250 jurisdiction, combined with his recent executive order on housing that usurps the discretion provided in statute to the Secretary of Natural Resources regarding wetlands. My point is that I urge you to retake and keep exclusions of language on exclusions of forestry and agriculture out of the rule. Don't let them get in, because I think they're not necessary and counterproductive, as I mentioned. Thank you.
Thank you, Thomas. I understand your comment, and we will take it into advisement. Alex, are we talking about Tier 3 as a board again before the rule is finalized and sent to ICAR? I think we are, obviously, right? So
Many more times.
yeah, so we can take that up, Thomas, when we next have it on the agenda.
Thank you.
Okay, thank you, Thomas. Next on the agenda, operations, budget, and legislative updates. And we will be talking about the fiscal 27 budget and the fiscal 26 budget amendment. So, Rachel, do you want to give any overview, or do you want to just entertain any questions?
Sure.
from the board?
There have been some revisions since we last spoke, and some questions that were resulting from our last meeting on Monday that I would like to address. I think the first relates to our budget adjustment, FY26 budget adjustment. The overall dollar value has been altered to be a total request of $41,250. This is really to accommodate our return to office and all of the new positions that we've added over the last several years. There were some comments about increasing costs for hardware and computer peripheral equipment, as well as accommodations for different ergonomic office equipment. So I don't know if there are other questions from the board members. I think you have seen the line items for the budget adjustment. Any questions or further discussion on that topic?
Sarah?
So I'm guessing we need to have a motion on that front to accept or to recommend. I'm not quite sure what the appropriate terms would be, Rachel.
I think I think accept is more appropriate than recommend.
I would agree with that.
I'm happy to make a motion, but I don't want to do that at the expense of other questions other board members might have.
Okay,
No further
Go ahead.
questions from me.
All right, I will make a motion to accept that budget adjustment as proposed.
thank you. Do we have a second?
I'll second.
Thank you, Brooke. Any further discussion on the Budget Amendment Act that we are hereby accepting or adopting to present to the legislature, I guess, yeah. So I guess no more discussion. All those in favor, please say aye. Aye.
Aye.
Aye.
Hi.
I didn't hear Brooke.
Aye.
Okay, that's 5. That's unanimous. Thank you for the vote on the Budget Adjustment Act.
So
Go
I
ahead
think-
with,
Yeah, the next question that I have is really about the expenditure of funds for accommodating return to office. This Budget Adjustment Act is going to be submitted as a proposal, but would not be approved until January, if it is approved at all. And in the interim, we do need to expend funds to move forward on a return to work plan across several different offices. I will just point out that we do have vacancy savings that have been realized this year in the turnover of existing staff positions. So I guess I am asking for the board's approval to expend some funds and related to those vacancy savings while this budget adjustment proposal is pending approval.
Sarah.
So moved.
Okay, thank you.
Second,
Thank you, Alex. Any discussion on that? Okay, all those in favor, please say aye. Aye.
Aye.
aye.
Aye.
Kirsten, you're muted.
Hi.
Thank you. I saw your hand go up, but you know. That is another unanimous motion. So Rachel, you have the permission to go forward with that work to implement our back to office plans.
Thank you, and I will keep the board informed. The last decision on this late today is our fiscal year 27 budget lines. I think there was a question last that resulted from last meeting about double checking the healthcare and benefits costs of all of our employees. I dove into that in detail earlier this week and, cross-checked some things with finance and management. Everything in the original proposal is accurate. Some of the differences between last year and this year relate to staff turnover and different staff members with different health benefit elections in different positions. So the 5% health insurance increase is applied, and all of our information is as up to date as possible in the budget system. Any other questions lingering about the fiscal year 27 budget lines?
See some shaking heads. Alex, you good? All your questions answered now?
Thanks, Rachel helped me understand things better at the last meeting. I'm good, thank you.
Okay,
So, I'm looking for the board's approval on these fiscal year 27, budget figures.
Sarah,
Guess I might as well go for the trifecta. So moved.
Second,
thank you. Any further discussion on the fiscal year 27 budget, proposed budget? All those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
aye.
And another unanimous vote. So Rachel, we are proposing that fiscal 27 budget
Thank
as
you.
prepared to the legislature.
Yep,
Um,
and can I just add
Yeah.
2 things? There will be an accompanying narrative to both the budget adjustment and the budget lines, kind of describing some of the nuances that may not come through in just a Excel spreadsheet. That's a standard practice that happens every year. And we have that all drafted up and ready to go. And we are on the schedule for a meeting with the Commissioner of Finance and Management to review this budget. That's currently scheduled for December 5th. And Pete and Janet and I are all on the docket to attend that meeting. I don't think I have any other updates other than that, but we can get this submitted and it'll go in for the October 14th deadline.
Okay, thank you. Alex,
Rachel, I trust you'll share that narrative with us when you submit the proposal to the governor's office. And
Yes.
thanks. And I also trust that the nuance, at least part of the nuance that's in it, is explaining why it appears that, we're at a 5 to 6% increase in our budget.
Yes.
Even though the governor directed us to try to keep it to a 3% increase.
That is precisely the thrust of the narrative. Yes.
Great, thank you.
Brooke,
I just wanted to recognize all the work that Rachel has produced to make it streamlined and facilitated our knowledge and understanding of this. Thank you very much for all of your efforts. It's really appreciated.
Thanks, Brooke.
further discussion of budgeting before we move on to legislative changes? Looks like we can do that. Pete, do you want to take up where we left off on the screen? And while you're finding that, I'll just point out that we've had a couple of meetings this week with RPC representatives and with legislative representatives, and actually with the governor's office, not necessarily about this, but I think that part of what came out of all of those meetings is that all of those entities are looking at their own lists, and some of the things that we have on here may be best left to those other groups. If we are focused on, a sort of precision fixes and corrections, there are others of these that fit with the goals of the governor's staff, with the RPC's thrust is clarifying things in Title 24 that would also help clarify some of the confusion around future land use map areas and tier 1B and, what's eligible for what and that sort of thing. And so I'm just going to suggest that where that lends itself, we don't need to prioritize some of these. So we left off at the interim exemption question, and Sarah had suggested packaging them as one. And I think that these are more policy oriented than they are fixes. And my recommendation is that we do perhaps suggest some of these to the other groups that are looking at changes. Alex.
This is a question for you. Number 16, I think is not a policy change. I think it's a technical correction. And I know our program has issued some guidance on it. And so my question to you, Pete, is do we need a legislative fix immediately for number 16? Or can we just, do you think it's okay to just work with our current guidance with regard to the interim exemptions and how it applies to subdivision unit numbers?
Yeah, good point, Alex. We have put this into our guidance and interpreted it that way. And I certainly legal can jump in here, but guidance document has less force of law than a rule or a legislative change. But there has not been any challenge to that interpretation in the guidance to date. Just kind of put that as a benchmark there. But I would describe that as a sort of a policy tweak rather than a shift.
Given that, Alex, are you okay perhaps suggesting this to the governor's staff instead of us? DHCD or?
Sure. Yes.
Okay. Is there anyone that feels that the board should be prioritizing any of these interim exemption tweaks? Brooke.
The one that I was most concerned about, because I thought it was a substantial EJ issue, had to do with the priority housing projects being, consistent, almost like perhaps this was forgotten, left out of the mix, or the protection to at least, ensure that all housing except that was not allowed there. So I don't remember if that was in what number that was on the list specifically. I'm trying to look at the version that I have.
Yeah,
It's 14.
It's incorporated within 14.
Okay, that's incorporated. Yeah. I think that one is important. I appreciate the other suggestions and fixes, but I think it does stand on its own in terms of not necessarily being a policy. I mean, it may be a policy issue, and if that's what the decision was, okay. But I feel like we should raise that. I think it's important because we're supposed to make sure that people are not treated in a less favorable fashion.
Yeah. Would you be comfortable, Brooke, in having us liaise with DHCD on this and expressing our concern about that in terms of our EJ and well, I don't know if they're covered. I guess they're not a covered agency, but we are. So
Yeah, I don't think it necessarily has to be like a proposal to the legislature to change it, but I think we should voice the concern and raise the issue in whatever form that you think is appropriate.
Okay. I mean, we could do it both ways. We could discuss these interim exemption tweaks with DHCD, and we could, make that suggestion to the legislature. They are going to want us to present in the committees of jurisdiction early in the session and talk about where we are. And they would be interested in hearing any recommendations that we might have. So that's something that we could do there rather than having a precise I mean, this number 14 is a broader,
Right.
it's a broader fix than just that. So maybe you and I can talk offline and come up with a very specific recommendation around that to bring. Okay, let's do that.
Great, thank you. And then the other general comment that I had, because I really haven't had a huge amount of time to look at these in any significant detail and trying to work through them. Is there anything that we've identified that we may have authority to, through rulemaking or policy guidance, be able, are we authorized? Is it not necessary to define the statutory language? So I'm not trying to assign a new job or anything, but I do want to keep that in mind to make sure that if this is already within our authority, sure, we would prefer clarification. But if there is not an appetite to get involved in things that are seen more as not necessarily a quick fix, then we should just keep our eye peeled for that kind of
Solution. Yeah.
yeah.
Okay. Thanks. All right. So are we all right to move past the interim exemptions and are there any of these actually that anybody would be opposed to turning over to DHCD to consider? Coming from us, like, is there something here where you don't think it's advisable and we shouldn't be even suggesting it to someone else to take on? Alex?
Only one minor item, and that has to do with the flood hazard area inconsistency in the interim exemptions. Right now, we refer to it as the priority housing projects, the hotel motel conversions, the commercial conversion to residential, and the ADU exemption. And I agree that that someone should raise the flag for priority housing projects because of the way the statute is constructed. It does seem like it was an oversight. I don't think that we should be proposing that Act 250 review is necessary for ADUs at all, anywhere, regardless of whether it's in a flood hazard area or not. I think that ADUs deserve a complete and total exemption from the Act 250 program, and that's what the Act 181 did. So that's the only one that I don't really want to parse with regard to flood hazard areas, in part because maybe at a later date, another legislative session, next biennium or such, I might like to advocate that interim exemption become permanent and not have it be location based, but just a flat out permanent exemption for folks who want to do an accessory dwelling unit.
Okay. Thanks, Alex. Pete, I expect you are taking some notes here in terms of board direction.
Yeah, and I mean, so to Alex's comment there, that's line 18, the permanency of accessory dwelling unit in terms of the, and we can keep that as a sort of a not opposed. We're going to, send that to DHCD along with the others, but in terms of the flood way inconsistencies, hazard areas, inconsistencies there, Alex has voiced his concern. Are others on board with that kind of clarification there?
Kirsten,
I'm more comfortable with ADUs being aligned as contemplated in item 14. So, you know, I don't think that even ADUs, we should be mindful of siting and avoidance of flood hazard areas and et cetera. But so I just don't know that we need to be jumping into that kind of policy consideration as a board.
Yeah, and I did add those all together because that's sort of the way that they came to me. But I will note that I think there was legislative discussion in terms of hotel motel conversion and commercial conversion, being given the nature of those exemptions, interim exemptions, they are buildings that already exist, right? Versus a PHP or an ADU that would potentially be a new building, not necessarily, but could be a new
Right.
building. And so that's kind of the distinction in terms of, whether, whether you'd make that flood considerations or not.
right? And I mean, not to get too down this rabbit hole, but the PHP and ADU that might be using existing buildings such as old mills or barns or something, when they are converted, they will have to meet flood proofing standards. They're not going to be exempt from flood hazard regulations. So same with hotel motel, I would think. Brooke.
So ADUs relate to single family dwellings, right?
Yes. Yes.
Okay. I mean, I see Alex's point, and I think the other argument to be made is PHPs, there's a public interest and an obligation, I think, attached to our EJ responsibilities. ADUs or single family homes, people can make choices for themselves if they are in a flood hazard area. I think that it's not as important from that public policy perspective, and I would be comfortable with ADUs being exempt. I'm not sure what role exactly we have in that. If the board wants to propose policy, I think that's pretty policy oriented, but I'm not opposed to it.
Sarah?
I agree with Brooke, and I can actually think of a case where you could have a parcel of land that's in the flood hazard area with a single unit that they choose to build an accessory unit up the hill and out of the floodway, perhaps as a solution. So there might be some times where an ADU would be triggered in the flood hazard area just simply because of the parent parcel and the parent unit. So I agree with Brooke, and by way of that with Alex.
Okay, any further discussion or direction for Pete on the interim exemption items on this list? Okay, Pete, let's scroll past them.
Right. Yeah, just as a benchmark here, we got about 50 total here, and we are on 20 enforcement.
So some of these, these are old housekeeping, like review penalty thresholds that have not been reviewed since 2007. And I don't think it's a priority right now. Brooke, go ahead.
Yeah, number 20, I mean, I see that as being applicable to so many, I mean, the government across the board. So I'm not sure exactly sure how they handle it, but typically it's like, sorry, it's under litigation, we can't give you documents.
Yeah.
So I mean, while it would be nice, I'm not sure that I see it as a priority unless our folks are saying this has really become cumbersome and we have to keep writing. And, I understand that in litigation, there are other attempts in other ways to acquire information, but unless it's a consistent problem for us, I'm not sure I want to waste the time or the resources at this moment. I don't think it should be
Right.
taken off the list.
Right. I agree. And just to clarify, this is enforcement investigations, which aren't necessarily under litigation yet. So I think it was sort of extending it to investigatory work. But I agree with you. I don't think it's something that should be prioritized right now.
I might highlight just 21 is the one, if I were to suggest anything for this session, it might be that one in conjunction with the other name changes that you were looking at as a technical correction where NRB still exists. This one does have it does have areas where it needs to be updated to LURB. There is a portion of that though that includes making it clarifying where the board's decision making lies versus the Agency of Natural Resources too.
So I think the name changing we already have on the list in a different line item, Pete, and it would include that here. So you're suggesting that there's a need for a clarification about board authority somewhere in chapter 201. Can you be more specific?
Yeah, pull up where that is. I see Rebecca's on, so if you want to jump in before me, that's fine. But let's see. I think it might be in a couple of different areas. Notice of alleged violation comes out as one off the top of my head, but let me see.
Yeah, let me suggest something on this one. This one is kind of complicated and I don't understand the way that the statute's written. There are a couple sections I think that we need to look at to understand, but it appears to me that there's either overlapping authority on enforcement, and I've understood that we work with A&R. Maybe there's an MOU or an agreement in terms of who takes the lead, depending on what the situation is, and somebody else can jump in if they know better information. But I think that maybe we should look at this offline. I'm not sure I'm prepared to make a decision on that.
There's not enough detail here, Pete, and maybe it's not worth the effort to do this on the fly during the meeting here, and maybe we can do a little background work on it to flesh it out a little.
Sure. Yeah,
Okay.
I did just flip to that page, and the notice of alleged violation does note the second, so just as an example, and then we can look into this more, but that one
Right, it
does
doesn't
specify
include the
the
board.
secretary versus doesn't
Yeah.
have the board, given the board direct
Yeah.
authority to do notices of alleged violation, so it's cleanup
Right.
like that. But
Right, and that's section 88006 and A and B. So I agree that, yeah, it should include the board. But since I think we need to bring it forth with more detail. So maybe we can do that and then come back at a later date.
And it may arguably just be a fix because it looks like, you know, the actual authority is in 8,000 or 80, whatever it is. So yeah, let's take a look at it offline.
Okay. And I think, I think that 23, I think is clear, and I don't think that we need clarity on this. There are, other than this section in, Title 10, there is the section in Title 24 that very clearly says that a municipality that is taken on in the Tier 1A status will be responsible for enforcing previously permitted Act 250 projects. So whose hand is up?
Mine, Thomas Weiss had a comment he wanted to make.
Oh, okay. Thomas?
Thank you, Thomas Weiss again. My comment has to go with some of the places where Natural Resources Board was not changed to Land Use Review Board. Act 181 has a session law section that directs the Legislative Council to make all of those changes when they updated to 2025. And obviously they didn't. My suggestion is that rather than bringing it up as a legislative fix, just coordinate first with the Legislative Council to just point these out to them so they can take care of it under the existing authority that they happen to miss the deadline on in all cases.
Yeah, thank
Yeah,
you,
thank you
Thomas.
for that. And we have followed up with them on that piece of it as well.
So would you agree, Pete, then that we don't need it as part of our legislative fix list?
I would keep
Keep
it
it
on
on
there
there?
just as a placeholder, make sure that it happens, but
That it
yeah,
happens.
they're aware. They did state that would that they would try to put it into a technical correction. But we'll want to just, I think it's important for our program. We'll want to make sure that does happen.
So going back to the Tier 1A enforcement, Alex, do you have a question on that?
I just want to agree with you, Janet. I don't think we should be suggesting a change here in this session. I'd like to leave like to have the statutory language be the way it is
Yeah.
for now.
Yep. And just the section that I think should be referred to here is section 4461 in Title 24, 4461H. Within a Tier 1A area, the appropriate municipal panel shall enforce any existing permits issued under 10 VSA Chapter 151 that has not had its permit conditions transferred to a municipal permit pursuant to subsection G of this section. And that subsection G just above this section H just explains that if a previously permitted project is amended, the appropriate municipal panel must take on any of the conditions of the Act 250 permit that are still relevant, that it may not have local regulations to address.
So
So that's 4460. You said 4461.
Oh, I'm sorry. Yep, 4460. Thank you, Sarah. Brooke.
I was originally concerned about the reasonable language not really being well defined, and I'm not as concerned about it. I've heard what you all have said, and the other issue is it may be up to us to decide what's reasonable. You know, if we are continually fielding reports, complaints about
Yep.
non-compliance, we notify the municipality, whatever, some time goes by, depending on the severity of the issue. It may just have to be a judgment call.
Yeah.
Or there may be a circumstance at the town where they need for us to come to their assistance. Who knows?
Yeah.
So I'm good with leaving it as it is.
So not prioritizing any changes in this regard right now. Thank you.
Right. And it could be kept as some kind of, gee, in the future, if we are under the gun or feel like people are, trying to appeal our discretionary, reasonable decision making, maybe there's
Yeah.
something that needs to be better specified by the legislature, but I think it's
Yeah.
probably okay to leave it as is.
Put it on page 3. As I was calling the least prioritized of the list. Pete.
Yeah, sorry, and just to clarify on this one, I think you all are on the right page with the statutory language as it exists for that particular point. This item was highlighting the fact that if a municipality has let's say they get a Tier 1A application or permit, not permit, sorry, they are designated as Tier 1A. They take on a permit and they issue their municipal permit in that area, and then we're called on enforcing that permit, but it has conditions that are different than conditions that would be put in on an Act 250 permit, whether we have the authority to then do that enforcement on it. I think it does state that we would be able to take enforcement action. And so that could be our authority, but under Chapter 201, it's not specifically outlined exactly how we would do that if that were the case. And I think, the other approach would be to just look at the revocation portion of that statute rather than the enforcement piece. But that's what this line item was
So I'm
looking at
not
highlighting.
entirely clear about what you were just describing, Pete. It sounded like you were saying that our program would take on enforcement of municipal conditions that were, subsequent to conditions that used to be Act 250 conditions. And if that's what you were saying, I would say no way. But now I see hands going down. I don't know what's going on here, but Kirsten's is still up. Go ahead, Kirsten.
I was just going to say that I agree with what Brooke was saying. And I'm thinking that we should see how this goes, and that we may want to come back with some other refinement or suggested language later. And I conceptually, I agree with you, Janet, insofar as if the municipality issues conditions under its bylaws, that our enforcement would be confined to only the Act 250 specific conditions, if that were to occur. So
yeah, I think we can put this on the back burner and deal with as we learn we may need to or not. Brooke.
Yeah, I don't think that we were given jurisdiction to enforce the municipal permit. I think the permit that is transferred from Act 250 to the municipality is the only permit we have authority to enforce.
Yeah.
Yeah, so I agree 100% with you. And you said it, so that's why I put my hand down.
So let's scroll to AOFB, and I'm going to suggest that we put this off because we have now committed to the ag committees that we will report to them in February on the AOFB question. So Pete, can you scroll past number 24? If I can sort of jettison our discussion on the AOFB. Okay.
I agree with omitting 24.
Or including it elsewhere is the thing.
Yep.
Sarah, is this 25 something you want to comment on?
Yeah, I think I had previously, I had said that I would really rather have V-Trans move forward on it because they're doing the study. And I just think that
Yeah.
sort of falls in lines with what you prefaced with at the beginning of this and saying that let others take pieces of this. And I think that's something that V-Trans can definitely take.
Yep. Okay.
And I don't know if you have other thoughts as being the other rep.
Are you asking me?
Yeah, your name
Okay,
got
sorry, I
cut
didn't
off,
catch my
but
name.
yes.
It's a little
Yeah.
audio hiccup. Yeah,
Yeah.
no, I agree with you, Sarah.
And then likewise, we are moving forward on the wood products items. I'm not sure that we need to discuss them today. They're sort of on their own track, and Kirsten is spearheading that. So can we move past them?
Yeah, that works
Just
for
make a-
everybody. Kirsten,
a
you've
quick
got your hand up.
mention. Yeah, so just to mention that item 29, the log and pulp concentration yards needs more board discussion of some of the detail. That's a
Okay.
component of, next steps for that one.
Okay, and do you want
Just
to
a
bring that
reminder.
to us at a future board meeting?
Yes.
Okay. Alex?
Yeah, so happy to wait for the future board meeting, but just curious because I believe our commitment was to craft statutory language to provide to legislators. Do you think we'll be able to do that, Kirsten, or are we not going to be able to meet that charge that we gave ourselves because we have staffing limitations?
I think we should be able to do it, but I don't want to, I don't want to speak for our attorneys, but depending on how the board discussion goes, it might be fairly straightforward.
It's just that if
So-
we're going to do it, we have to do it in the next, Pete, you tell me, but I think we have to do it in the next 3 to 4 weeks. Otherwise, it's too late for legislators to be able to do something with it this legislative session.
Yeah, I mean, they've got to get their request in by the beginning of December, so there is a little bit of time, but yeah, for the more pieces that you work on, the more thin you are in terms of support on each one of them, of course. So that's something else to be considering or thinking about.
Yeah, and I would just prioritize this one because we already delivered the report and pledged to do it, and I want to follow through on what we said
Yeah,
we would do.
I agree, Alex.
Rebecca?
Yeah, so it's hard on the spot to say what the legal team's capacity is going to be when we're just on paragraph 29 of 50. So I think it would be good first to have you, like, it sounds like, you're narrowing down what are the ones that you do want to highlight or that you'd like to be able to do. And I think at that point, we can look at the list and let you know, like it's just difficult for me even to right now to think about what would be involved in that drafting and depending on which ones. So
Yeah.
what I would ask is like, let's get this refined as what you're doing today. And then I'd be happy to work with Jenny on it to take a look at and let you know what we think we can get done. So if there's further prioritization that is needed, we can do that.
And Rebecca, what I'm anticipating is that what's going to get priority are these true corrections and fixes, and then maybe the wood product stuff, because as Alex said we were going to do this, and that other things that require a lot of effort we're not going to prioritize.
Okay. Sounds good. Thank you.
Yeah. So this next one, the tiers, this is something that the RPCs are pursuing. So these are that one is a Title 24 effort that they are already involved in. And so I don't know that we need to discuss it, unless you want to suggest, unless you're not supportive of that, and you want to tell them we don't support this, but Frankly, I think that the minor FLU map amendment procedure that is mapped out in statute is not very useful. I don't think we're going to see a lot of those. And I think that because it's so restrictive, and I think that, you know, in the end, I would support carving out different processes that are a little less limiting than this. So, but as I said, the RPCs are already pursuing this. Any thoughts from the board on that? Okay.
I'm basically categorizing those that others would support, would be leading, that we agree with, we would just be not opposing.
Right, right. Tier 1B exemption area, remove 10-acre size limit, and that's a little bit of a policy change, and I'm not feeling that we should prioritize that. If somebody else wants to, we could suggest it to them. What do you all think? I think the legislature made that policy decision. It wasn't a mistake.
I have
I
the same
agree.
perspective, Janet. I think the policy needs to change. This was one I suggested, I think, but I agree. Given our workload and what we're interested in, this would be a talk about it later or let somebody else lead the charge.
You know, DHCD might like it. So, extension of tier 3 rule. I think we're past this.
We've already done that one and the next one, so we can move on to number
Yeah.
34.
Yeah. Yep. Downtown findings. I don't know. I don't feel any urgency about this. Does anybody else? I'm seeing some heads shaking. Sarah, your head didn't shake.
This is kind of a long-term thing. I mean, this process 6086B is out there. It's rarely used. It seems to be that it will not really be very relevant once the tiers are put into place, tier 1A and tier 1B. That, you know, something you can look at down the road.
Okay.
My recommendation.
I agree.
30.
I was just stopping to try and read the small print on my screen.
Okay. Kirsten?
I agree. I just have a quick question for maybe Pete. Is anyone aware of any conflict with the 6086B designated downtown findings process and the new tiers that will be going into effect? Because I'm not aware of any conflict. If anyone else is aware of a conflict, I would like to know, in which case we should prioritize. But I agree it's a longer term thing and rarely used.
Yeah, not aware of one at the moment.
Not aware. Okay, thanks, Pete.
I think
number 35 is the same or similar
yeah.
to the one we talked about earlier. So
Yeah.
let's move on now.
Yeah. Yeah, I agree, Alex. Same as the 10-acre thing. Tier 1A and jurisdictional opinions. So yeah, I mean, if somebody has tier 1A, why should we be issuing jurisdictional opinions there? Right? We shouldn't be issuing jurisdictional opinions in areas where there is Act 250 exemption generally.
But what's the problem with just issuing a jurisdictional opinion that says this area is tier 1A and exempt? There is no jurisdiction. Isn't that the opinion that would be given? I don't know what the problem is that we're trying to fix here on this one.
I think the issue that's been, well, there's some hands up. Yeah, go ahead.
Brooke?
Well, go ahead and tell me what the issue is, because I'm not seeing an issue either. You could write
Yeah,
a
I
laundry
think there's
list of places that, it's not applicable.
I think there's a perceived issue that if a jurisdictional opinion is issued, then it opens up an avenue for an appeal right
Yeah,
to a project where there wouldn't otherwise be one. So making that explicit that one is not allowed or requested. And it also might, I have not delved into the financing side of it, but I have heard from folks that oftentimes when they are in an area that, could or may not require an Act 250 permit, they want that letter, that certainty from Act 250 that would allow them to get their financing through. So I think if there's something explicit in the statute that says you just don't even need one, then that might help those folks from the financing perspective. So that's my 2 cents on those.
Well, then my reaction is cut off appeal rights. Don't say that somebody can't ask for a JO, because, somebody could be next to a tier 1A area and start building and pretending that they're in the 1A area, and somebody could say, wait a minute, you're not there. Let me go get a JO. I get what you're saying, but I don't know. I think that's an easier way to stop the problem from it.
I
Yeah.
think there's intent that within a tier 1A area, once a community has that, it's really then the municipality to make a decision and not Act 250 anymore. I think that is the direction that we need to go in, because you could have a zoning administrator in tier 1A municipality issue a permit's needed, and a district coordinator issue something that's not, and you sort of had this intersection. So I think at some point this should get cleared up. I think right now it maybe isn't as much of a priority because we don't have any tier 1A areas to contend with, but I think it's one of those that we should put a stop on it and say in tier 1A areas, Act 250 is no longer doing jurisdictional opinions because there are multiple conflicts. There's a possibility for appeals, and clarify that really is something that if you want that like piece for financing, go see your local ZA. That's the person that you should be. So
right. We don't have jurisdiction. And Brooke, for somebody who's right next to the boundary, we have jurisdiction. So we can issue that JO. Kirsten.
Yeah, so what Sarah just said makes sense to me. At first I was kind of, well, this seems to be like a solution in search of a problem, but I could see some usefulness. I don't know how much we need to prioritize this when we're busy with so many things, but so maybe it's sort of on list number 2, but I'm okay with including it now if that's the direction we take. But I don't see this as a high priority item, but others might.
Any changed minds from initial, Brooke?
Yeah, my only concern is like, all right, if I write in for a JO and I just give an address, there has to be some, how's the district coordinator gonna know? Will they already know? They just will look at it on the map and be able to just say, sorry, you're in the wrong place.
Yeah.
Okay. All right. Well,
Yeah.
I get it. That's fine.
Okay. Kirsten?
Well, yeah, just a quick mention. I think that some of this may become a little bit, hate to say, like a little bit more complex, where you have an Act 250 permit that straddles the line of a tier 1A boundary. And I think we just need to be really careful with any statutory language that limits JOs, that it would be confined to that tier 1A boundary
Yep.
And there may be projects, like I said, an underlying Act 250 permits that straddle the boundary. And so if, all or a portion of the project is outside of Tier 1A, but there may be some residual elements of the project or the permit history that are within the boundary, I just think we need to be careful. And I
Yeah.
don't know if we want to define project as part of this. Like, I guess I think we should be careful with that too. So I'm just.
Yeah. So we're gonna put this on page 2 anyway, so let's just come back to it and not discuss it further today. It seems like we have decided to not make it our top priority. This Tier 1B, separate Tier 1B requests, that is something that is in Title 10. So it's not something that the RPCs are taking up, and it's not a fix necessarily, or maybe it is, I'm not sure, but making separate Tier 1B requests go through the pre-application process to me seems a little bit absurd. But statute is constructed currently to send them through the whole process. So I wouldn't mind putting this out there this year. What do the rest of you think? Alex?
I think this is a low priority item that we could deal with in the future. We don't have any Tier 1B areas, and they're all going to come to us through the regional plans over the next year. So I prefer to just wait and see, and then if we need to address it, we could do it in the next biennium.
Okay, I'm good with that. And I see 2 more nods. What about you, Brooke? Okay, let's keep going. What time is it? Let's see, 2:06. Oh, we've got
10 minutes or
9
so.
minutes left.
Yeah.
This is something that the RPCs are taking up, so let's keep going. RPCs, well, no, they're not necessarily taking up that. That's a Title 10. I mean, I think we've sort of dealt with this in our guidance. So I don't think it's a priority right now.
You're talking about
Remember
item 39?
Yeah, remember we talked
Yeah.
about that when we adopted the guidance for Regional Planning Commission applications. The number 40 is something that the Act 181 never said which FLUs are eligible for Tier 1B. But the RPCs are taking this up with a fix in Title 24. So I don't think we need to address it. What they're doing is in Title 24 under number 12 under the future land use element, they're in the descriptions and definitions of the future land use areas, they will say which ones are eligible for what. So can we move on to 41? Oh, that's a quagmire that I'm not interested in addressing right now. 41, anybody feel strongly that we need to sort all that out?
Agreed, it looks sufficiently messy that it should wait.
Yeah, okay. And then these 42, 43, 44 are all being taken up by the RPCs. Oh, wait, actually, no, number 44 is not. But I don't think that we need go there on number 44. We haven't even done this yet, and we'll see whether it's doable. I think it is. Particularly if we front load everything, try to get as much as we can in the pre-application phase, and we hold that hearing toward, give ourselves some time before we hold that hearing to review the plan. I think we'll be all right.
Yeah, that you're on 45.
44.
44 is flood requirements for village areas and planned growth areas.
No, it's giving the board more time to issue a decision. Am I not
Okay.
reading the same thing?
43 here is the consistent flood requirements.
Yeah. Yeah, and that's something that I think the RPCs are addressing. So I jumped to 44. Sorry, Alex.
No,
So I'm
it's
talking
okay.
about the amount of time that we have as a board to issue a determination after the close of a hearing. Kirsten.
So I agree in that I think we should see if we can just meet the time frame as already specified in statute, but I just have a quick jog my memory question. If the board does not issue its decision within the required 15 days, I think it's deemed approved or favorable determination. Is that correct?
I don't think that language is in statute. Is it, Rebecca? Do you recall? I don't
Not
think
to
it's
my
deemed.
not to my
Okay.
recollection. It's not one if we don't respond, it's approved.
Okay.
Yeah.
Okay. Thank you.
This next one, though, 45, this one is kind of a problem. And Sarah, I don't know if you want to take this and talk about it, but and we did sort of talk about this. Alex in particular called it out when we discussed Sarah's draft guidance.
So I think there are two things that were putting us into a more robust pre-application process. And I think one of them was having sort of wide open criteria and narrative as opposed to very specific standards. Given the fact that we are not likely to see a Tier 1A application until the spring, and we are, I think, settled on a robust pre-application process, at least for the first few ones, to be able to better judge and hone in. I think this might not necessarily be this might be a page 2 as opposed to a page 1, I think, to use your analogy. It would be nice, but I'm not sure, given the fact that we haven't even processed one yet, that
Okay.
that's necessarily ripe to be asked for at this point.
Alex, are you concerned about the timing for Tier 1A application process?
I am, but I'm happy to defer to Sarah if she feels like we can muddle through in the short term. I do
Okay.
think this needs to be fixed eventually, but I suppose we can wait till the next biennium.
Okay. Number 46, I'm not that concerned with. Is anybody feeling that we need to prioritize that? This is consistency of terminology for approval. We are consistently using the term determination, and we are using affirmative or negative determination in our guidance. And we can be consistent that way. So, not too worried. Anybody? Kirsten?
I'm not worried, but I just wonder if we're putting forward these other minor technical corrections, maybe we just include this one. Seems straightforward.
I think
Not a big
finding
deal
all
either
the
way.
places where they say approved versus confirmed is not necessarily that straightforward.
Oh,
I
okay.
don't,
Okay.
and it starts mixing up with the terminology that's used for regional plan approval and amendment and readoption. And so I just think it's a little more of a quagmire than we need to
Okay.
get in right now.
Yes, I'm fine with leaving it alone, at least for now.
Number 47, the RPCs are addressing. So I think we can move on.
Those two as well.
Yeah, we talked to them about that. So planned growth areas and village areas clarifications. And then where are we now?
50.
50. I think they're
We
addressing
talked to
that as
them
well.
about that
Yeah,
too. Yep.
yeah. 51.
They really wanted to do this one, I think.
I wanted to do this one. And we passed it along to them, and I think they'll take it up. But I just think it's funny. It basically says to the RPC, submit your plan to the LURB, but then the word for is left out, so it kind of doesn't really tell the LURB or tell anybody what the LURB's going to do with it, clearly. Anyway, so 52. Changes to designation program and Tier 1AB will negatively affect the incentives for building affordable housing. That's a policy issue. Sarah.
And I think that there are other ways that municipalities can address this through inclusionary zoning, and if they are proposing a tier 1A. So there are other tools in the toolkit that municipalities can avail themselves, I think, of to address it in the interim. And I would agree, this is maybe a page 2, not page 1.
Mm-hmm. So actually, is that the end? And we're only a minute over?
Yeah, there was, I don't know if anybody else had any other ones they wanted to raise or bring to the table. There was one other one in the 8C language where undo was used sort of unnecessarily. That could cause confusion.
Maybe we can leave that to our 8C process, to identify as a problem, if it is going to be. We haven't really gone through that process yet, so. But this is it, right? There's nothing, this is the last page.
Yeah, unless there's anything
Okay.
else folks want to add.
So,
Yep.
I think we're good. Let's keep going to the next agenda item. Unless are there any comments from anybody in attendance on what the board is hoping to prioritize in terms of legislative tweaks or fixes regarding our work? Luke is shaking his head. What about Thomas?
I've been trying to keep up with whether these items are on pages 1, 2, or 3, so I would appreciate that quickly being released to the public, which ones are on which priority.
Oh, okay, sure. That's Pete's taking all of this under advisement and revising that list, Thomas. You'll be the first to know.
Okay,
I will revise
remember
and-
that priorities were going to be added to that list, so I think that's where they show up.
Okay,
Anyway, thank you.
Yeah, thank
Okay.
you all for input on it, and I will clean up the list and par it down as we've discussed and share it out.
thank you, Pete. So next on the agenda is the Northwest Regional Planning Commission pre-application completeness determination and board designee assignment. We have received, and maybe just I'll share my screen. Are you seeing the database? Are you seeing the Northwest Regional Planning Commission's application document list?
Yes.
Okay. So we have the pre-application form. We have a draft regional plan. We have the draft regional plan review checklist. We have the Tier 1B memorandum and confirmation letters for the municipalities that are seeking Tier 1B status. We also have a notice from VNRC a request from VNRC that they want to be noticed. So think the only thing I don't see here is the map link, but we do have that. Why am I not seeing it here?
It's
Actually,
gonna be
if
my
we,
question, Janet, is do we have the future land use area map?
we do, I don't know why it's not in that list, but if I go here and look at,
It shows
The
up
wo-
if you pull up Rutland's, it shows up.
yeah, I know. So the data layer, so if you click on the data layer link here, you'll see that both of them pop up on the map viewer. And I'll show you that in just a moment. Are you seeing that?
Yeah, this is Maddie. Just a quick point here. We haven't really figured out what is the best way to put like the exhibit of the GIS map into the database. So for the Rutland application, this GIS layer wasn't even finalized yet. So they had sent the URL to me, which is what I put in a Word document and then stamped. But I didn't get that with the Northwest because they just submitted it directly to the GIS
Right.
folks. So I think this is part of the process that we still need to maybe iron out some details, but I can create a document that has a URL link directly to the Northwest. I just didn't do that because there was a lot going on. So just throwing that out there.
Maddie, wouldn't it be the same exact link that we have for the Rutland? I mean, it's the viewer.
Yeah, I guess it would be. I think maybe this is something we can talk about in terms of like application materials and things that we want submitted. Like, what is the best way for our database to be able to link to this map viewer, whether that's with a PDF, with a hyperlink, or some
Okay,
other way? I'm not sure, but we haven't required applicants to send a Word document with the hyperlink to the map. That's just something that I did in the interim. So
I see. I
um,
see. Okay,
still
well, we
something
can
to be
talk.
ironed out.
Yeah, we can talk about that offline. But the point is, here is the data for Northwest. It's on our viewer. So, I think we have two jobs here to determine the application complete and to designate a board member to coordinate the review.
If you're all set with sharing, would you mind stopping
Oh,
sharing?
yes.
So like last time, I would suggest that whoever has actually looked at this to determine whether it's complete, make that motion. I have not, so all I know is what you just showed on screen, Janet. Looks good to me. But I can't really, I don't want to be the one to move that it's complete.
I have, and Kirsten, have you?
I have, but I would say it's been more cursory, I haven't read the whole thing.
Right,
Just
right,
came
but
in.
but the elements are there. The
Yeah.
elements of a complete application are there.
Yes, that's my interpretation of the submittal.
Would you like to make that motion that this application is complete?
Sure, I would like to make a motion that the application received from the Northwest Regional Planning Commission, which has been assigned project number RPC 08-0001, be deemed, the pre-application be deemed complete.
Do we have a second?
I'll second.
Thank you, Sarah. Any discussion? All those in favor, please say aye. Aye.
Aye.
Aye.
That was all 5 board members. That is unanimous. If you would entertain me making a motion, can I do that?
Yes,
I would like
Yes.
to move that Kirsten Sultan be named the board member to coordinate the Northwest Regional Planning Commission pre-application review.
Second.
Thank you. Any discussion? All those in favor, please say aye. Aye.
Aye.
Aye.
Hi.
Okay, that is another 5 board members voting to pass that motion. So Kirsten will be the designated board member to coordinate that review. Thank you, Kirsten, for stepping up.
Yeah.
Thank you, Luke, for attending our meeting.
Yeah,
Yeah.
thanks. Just wanted to make sure everything went smoothly. And yeah, glad we made it through the first step in the process, at least.
Yeah.
Yep.
Okay. Next on the agenda, studies and reports. And we are right on time. Look at that. So we have, very briefly, obviously, we're looking at the Northwest Regional Plan right now, the draft plan. And we are also looking at the Rutland pre-application, for which we have a meeting next week, next Thursday in Rutland, starting with a 3.5 hour-ish bus tour showing us some of the Tier 1B areas. We are soon expecting a third application, so be prepared. Alex, do you have Tier 3 reporting to do today? Updating?
Just a quick update that the second draft of the rules is finally ready. I just need to get it to Maddie with some other documentation for the website. And then I'll be sending out press releases for the late October public engagement sessions across the state. So if anybody asks, hopefully they'll wait to ask until tomorrow, the next day, when the website's up to date and everything is ready to go. Yeah, that's the Tier 3 update. And on Criterion 8C, Kirsten and I have a second working group meeting tomorrow.
Okay, great. Sarah, do you have any updates for us?
So I think Kirsten and I are continuing to make some progress on the road rule and appreciate Pete shared with us the thoughts of the coordinators from the coordinators retreat, and sort of parsing through that. Hopefully we'll be moving forward with that. Tier 1A continues to plot forward. I think continuing to hear some good feedback on the application guidance, and we'll be presenting at Municipal Day next week, and look forward to hearing some more comments and feedback on that. So hopefully by the end of October, we'll bring that back. I think the other thing that I'm working with Kirsten on is Tier 2. And I think you had already touched upon the accessory on the farm. And I think working with Kirsten, I'll sort of hand it virtually over to her to comment on that. And I think we're probably going to go with that.
Yeah, I think everyone's covered everything. So now that we have an indication of the status of the Tier 2 report extension request, that we envision that we will be advancing and prioritizing the accessory on farm business component of that Tier 2 study obligation. And we've talked about leveraging existing known working group members, stakeholder group members, but similar to the road construction guidance document that we're working on, developing something in-house. So we're sort of at a early stage of, gathering up some historical relevant information and starting to get going on that. But it's a brand new study area that we're just embarking on together. So stay tuned.
Yep, thanks. And Brooke.
For the appeals study, we'll be looking at the first draft next Wednesday for the board review of it. And then we will post that by next Friday so that the public will be able to review the document after any changes or alterations made as a result of the board meeting. And that will be posted for 6 days. We will then be convening a public hearing on the 23rd. And the public comment period will continue until that following Monday. I'm not remembering what the date is, so that we have not only public comment available prior to the hearing before the board, so that we can take stakeholder public verbal comments, but then after the meeting, we will have several days as well, which I think is a better mix of opportunities for people to speak out of the gate and then after the actual meeting. The one issue that I just wanted to run by the board, because I have had to go back and understand and research how on the issue of discovery and motion practice to effectively not eliminate it, but curtail it to the degree possible. And it turns out, actually called David Grake because I was trying to get an understanding of when the e-board was operating, about motion practice, etc. And the thing that raised my concern was that in reviewing the APA contested case provisions, there was an indication that if a subpoena were caught or not honored, or there was a motion about a subpoena before the board under the APA, there was an appeal for the individual to go to Superior Court to get a subpoena enforced or a protective order on it or something of that nature. So I needed to understand, now wait a minute, are we under the APA, and if not, and we want to deviate those requirements, have to make sure that we are able to do that and have the authority. And I know it's possible. I know the PUC operates that way. And so I had to do a little research to really understand how we can deviate from APA. And we have the ability to do that. But to really be able to create that demonstratable savings in time of those two aspects of the litigation. How much can we shut down discovery and motion practice? So the answer to that question is we can curtail discovery and shorten the deadlines from the civil rules to very short time frames. So that's great. We can also say, you're not justified to sit down and ask for depositions or that kind of discovery. And we will have our process with deadlines for the scheduling of the case that are general, and they might be able to be altered with a good showing if I need more time, but we're going to try to keep those timeframes tight. Now, the issue of motion practice, because of this subpoena, you can go to the court. That's one area that we cannot eliminate motion practice unless it's going to be left to the courts. But I think that we do have the ability, based on the PUC experience and rules, to also establish very short deadlines to responding to motions. And I'm not suggesting that we do so wholesale, not on dispositive summary judgment motions, but I think that this is the only option that I can really offer to in any way control or mitigate the amount of time that's spent on motion practice. So it's effective at the PUC, but that does take more case management from the appellate tribunal. So the other thing that I also wanted to just run by you are the actual roles for the board versus the lawyers. And the one thing I want to ask the board, what your preference is. I think that we need a case manager of each case. And I think that should either be like the board or the hearing panel chair who's going to run the hearing. Or you can call them hearing officer, whatever, but I think that we need maybe that individual board member to be the case manager, or because I don't necessarily think that the lawyers that our board counsel should be doing that function. I think the one who's in charge of the hearing as the board member should be that individual. Does that sound appropriate?
Yeah,
And what
I
that,
think
and
so.
that person would be convening a status conference in the beginning to set the schedule, see if everyone's in agreement with the timeframes. And you organize the case that way and hear about issues and try to narrow them at that juncture. So it's important for somebody who understands the substance of the case to be in charge. Normally it's the judges. At the court, it used to be at one point in time a staff attorney. But now let me just finish by saying, and the role then of our board counsel will be to assist us with any legal motions, evidentiary objections, and the writing of legal opinions, and making sure that the board issued decisions are legally up to snuff as well, substantively.
Alex, did you have a question? Your hand was up briefly.
Brooke answered it mostly. I was going to ask, what are the functions of the case manager? You described them. It sounds like what you're proposing makes sense to me. You were asking if that made sense. I think it does. I do think that some of the scheduling and such that a case manager might do that you describe, could be directed by the case manager, but handled by a legal technician once the case manager's made some decisions about narrowing scope and that sort of thing. But yeah, in general, what you're proposing sounds right to me.
Okay.
Great.
Then I think we're good. I'm shutting down the others as much as possible, and I am very much following the PUC's rules in that regard. They are not necessarily specific to timeframes, but that comes out in those scheduling orders when things are asked for. And just to give you a context for this, if you ask for interrogatories in civil court, the other side gets 30 days to respond. Very often, it is not unusual at all at the PUC. When interrogatories are served, you have to answer them 1 week later. So it's a pretty compressed time frame that has passed muster as an administrative tribunal in Vermont. So
Thanks.
it doesn't mean that we have to shut it down to 7 days, but we know that we have that flexibility to be able to shorten as much as possible because we don't have to follow the civil rules.
Okay, great. Thanks. Any questions for Brooke? And Brooke, anything else that you need before you finalize a draft? Maybe that's an oxymoron, a finalized draft, but
no, I think it's going to come out over the weekend.
Okay.
If I have
Sorry.
any holes
supposed
in
to
the
be-
fabric.
aren't we supposed to have really bad weather? So might as well, right? Nose to the grindstone, Brooke. Sorry.
It's okay. It's been actually a wonderful experience and very interesting. And our stakeholders have been amazing with their input. So it's a tough question.
Yeah. Okay, so that is item F on our agenda, studies and reports from the board. We can move on to item G unless there is any further discussion on board studies and reports. I don't see any. All right. Do we have a motion to go into executive session to discuss appeals, enforcement, and attorney-client communications?
Sure, I'll make that motion.
Go ahead.
I was going to just use the words that came out of your mouth, but sure, I'll make a separate motion that we enter into executive session to discuss appeals, enforcement, and have attorney-client communications with the understanding that premature disclosure of those matters would put the board at a substantial disadvantage.
Thank you, Alex.
I'll second.
Thank you, Brooke. Any discussion? Okay, all those in favor, please say aye. Aye.
Aye.
That is all 5 board members in the affirmative. So we will leave this meeting, discuss in executive session, and come back here to report out anything, any decisions, and to adjourn. Thank you, everybody. See you soon.
Hey, Maddie?
Hey Brooke, what's up?
I have exited executive session due to a conflict of interest on a matter, so I am just going to wait back here in the meeting.
Okay, sounds good.
Thanks.
Thanks for the heads up. You're muted, Janet.
Sorry. Okay, we are still recording. Sarah, you must have a motion.
I would like to move to authorize enforcement with regard to 2021-099 to transmit a proposed AOD with directive to rectify the deficiencies in an incomplete LUP application number 3W1129 and pay a $3,000 civil penalty.
Okay, thank you.
I'll second.
Thank you, Brooke. All those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
Aye.
Okay, that is 5 affirmative votes. That motion passes.
So I have a motion in a moment.
Okay,
Apology.
I'm happy to make the motion, Kirsten. I think I
Do
know
you have
what
it up? I apologize.
you do. Yeah, so
Thank
I'll
you.
make a motion to authorize enforcement to send a notice of alleged violation to the respondent in enforcement case 2025_098.
okay, thank you.
I will second and I concur. That's the one I was looking for.
Thank you. Any discussion? All those in favor, please. Oh,
Janet,
sorry. Yeah, I forgot.
For
Brooke, go
discussion,
ahead.
just to put on the record that I recused myself and was not present at executive session on this matter, and I will be abstaining from the vote.
Thank you, Brooke. Okay, all those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
That is all 4 who are not abstaining, voting in the affirmative. So that passes that motion. Thank you, Sarah.
Motion to adjourn?
Thank you.
Second.
Thank you, Kirsten. All those in favor, please say aye. Aye.
Aye.
Aye.
Aye.
Brooke, did you say aye?
Aye, yes.
Okay, it's unanimous. See ya.
Thanks, folks. Thanks, Maddie.